Alternatively, if you license, or what I like to call lease out your rights, the licensing contract will determine how long the license lasts, but it's usually written as irrevocable and perpetual, which means that the license lasts forever and you can't go back and change your mind and revoke the license. Except for this clause in the Copyright Act. Aha. Aha.
My faith rising. I'm crawling out the trenches, holding me. My life.
Hello, visionaries. Welcome back to my channel. You already know who this is. My name is Maresa Talbert. I'm the founder and CEO of Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. All right, so this is a moment to keep it real. Raise your hand in the comments if you've ever given something away and wished you could take it all back. All right, don't leave me hanging. I know I'm not the only one. It could be your love, your time, your food, some clothes, or even a ride down the street. But after you gave away your time, your energy, your money, you name it, now you're ready to say, you know what? Give it all back. Well, the same can be said when creators grant rights in their creative assets and then later on want to take those rights back. We've talked about copyrights on this channel before, so you all should be a little bit familiar on what types of works are copyrightable. But just to refresh, this can include music, lyrics, books, choreography, scripts, 2D and 3D art, and so much more. So now what happens if you're a freelance designer that designed the Jordan 1s and you sold your copyrighted design to Nike and now Nike makes billions off of your design? Or what happens if you wrote a movie script and you sold that movie script to Paramount Pictures or Lionsgate or any of the major movie publishing companies? And then later your script ended up being a hit movie franchise like Top Gun or Friday. What would you do? That might make you want to take all your rights back, don't you think? Sometimes it's really hard to know how valuable your creative genius will be in the future. And that puts creators at a huge disadvantage when they're negotiating deals. But I got something for you. And it's called copyright termination rights. Take a look at this short clip featuring a pretty well-known music artist that is talking about getting his rights back from the record label. And then we'll jump right into it.
When we did our deal and streaming didn't exist, we went from vinyl to cassette to CD. You know what I'm saying? So when I did my deal, those were the three forms. Streaming didn't exist. So how is a motherfucker tell me they're gonna give me $1 for 1,000 streams? I never negotiated that. Nobody that put out a record before streaming existed negotiated that. No one. So how, once again, are you going to tell me what you going to give me for my intellectual property?
Yeah, got you.
You know what I'm saying? So, and you going to give me $1 for 1,000 streams? That's mighty whitey. You know what I'm saying? Like, you know what I'm saying? Like, at the end of the day, I'm like, yo, nah, that's not what we're going to do. Right, you know what I'm saying? That's not what we're going to do. So I had to look back and find out, oh, in my contract, there's language that speaks to unforeseen. If there's an unforeseen way that we're selling selling music other than vinyl, CD, and cassette, whatever that is, in my contract, we split that 50-50. Which means since 2008, when y'all started streaming, y'all niggas owe me 50% of every fucking stream I've ever had. Not only me, but every artist that did a deal before streaming. Do you own your publishing? I own half of it. I'm about to own all of it. And that's how the shit came about, because I was doing a deal with my lawyer. My lawyer put me onto a clause from 1976
that they only get to keep it for
35 years.
Right. You
Now,
get it back.
but mind you, but peep the nuance. The nuance is this: you have to have the paperwork filled out and filed 2 years prior. If you don't have it done 2 years prior,
The 33rd year.
right? The 33rd year, you have to have it done. If it's not done 2 years prior to 34th year, it's too late.
Wow.
And it effectively just rolls over.
Oh, that's crazy.
That's crazy. Right. So when you find out about something, you think, oh, in 35 years I could do it. You go to address it at 35 years, nigga, you missed the boat already.
So there are a lot of nuggets in this 2-minute clip. First of all, he talks about contracts. Y'all already know how I feel about contracts, and I got a gift for you coming soon. But in this video, we're going to focus on that 35 year situation that he referenced. So when you federally register a copyright, that copyright lasts for the life of the author plus 70 years. So if I wrote a book, the copyright on my book would last for my entire lifetime plus 70 years. That's a long time. More importantly, if you sell your rights, that protection effectively transfers to the person that you sold your rights to, which is your lifetime plus 70 years. Alternatively, if you license, or what I like to call lease out your rights, the licensing contract will determine how long the license lasts, but it's usually written as irrevocable and perpetual, which means that the license lasts forever and you can't go back and change your mind and revoke the license. Except for this clause in the Copyright Act. Aha. This clause allows a creator to terminate the rights that they have granted away after 35 years. Now, 35 years sounds like a lot until you go back and consider that copyright protection lasts for the life of the author plus 70 years. So the hip-hop duo Black Sheep is seeking to gain control over their copyrighted music. And what was being referenced in the video is that in order to exercise those termination rights, you have to file the paperwork by the 33rd year. Or else you don't get another chance to revoke your rights until year 70, which would effectively be until year 68. Another thing to keep in mind is that these termination rights don't just apply to the creator themselves. The creator's heirs or representatives can fight to regain these rights in the appropriate year if the creator has already transitioned. But let me be clear. These termination rights can only be exercised if you have a federally registered copyright. And there are a few exceptions to these termination rights, but don't think it can't happen to you. Get yourself a good lawyer, because, we kind of know some things. Protect your assets, own it outright, safeguard your legacy. And of course, your girl is here to help you do that. Well, that is all I have for this video. If you'd like for me to do a part 2 and explain the process for how to actually terminate these rights, type terminate down in the comments. Of course, I'd also love to hear your feedback and your questions. Don't forget to give this video a thumbs up, subscribe, and share with a friend. And as always, this is Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. I'll see you in the next video.
I done made it this far. I'ma keep it pushing, yeah. Even made it through the